Welcome, bienvenue. LexisNexis Canada is proud and honored to present the webinar, A Conversation with Beverley McLachlin on Access to Justice. LexisNexis Canada est fier de recevoir la très honorable Beverley McLachlin pour une discussion sur l'accès à la justice. Pour faciliter le déroulement de cet événement, veuillez noter que la présentation est en anglais. My name is Kristen Schmitz. I am the Ottawa Bureau Chief of the Lawyers Daily, LexisNexis Canada's national online legal news service. We are deeply honored to have with us today Canada's preeminent jurist, the Right Honourable Beverley McLachlin. She is a living pioneer, having been the first woman and longest-serving Chief Justice of Canada until 2017. She now works as an arbitrator and mediator domestically and internationally through Arbitration Place. She is also a judge of Singapore's International Commercial Court and of the Hong Kong Final Court of Appeal. As well, Ms. McLachlin is a best-selling mystery novelist, and she writes a regular column for the Access to Justice section of the Lawyers Daily. She is also the originating author of LexisNexis Canada's popular publications McLachlin and Taylor, British Columbia Court Forms 2nd edition, and McLachlin and Taylor, British Columbia Practice 3rd edition. She has also co-authored the forthcoming 3rd edition of the Canadian Law of Architecture and Engineering, to be published by LexisNexis in early 2020. In September, Simon & Schuster published her memoir, Truth Be Told, My Journey Through Life and the Law, which I could not put down and read through in 2 sittings. She joins us today, however, in her capacity as chair of the Action Committee on Access to Justice in Civil and Family Matters, the national coordinating body she established in 2007 that works to lead, support, and highlight the efforts across Canada by thousands of people and groups who are working to enhance access to justice. Welcome, Ms. McLachlin. Thank you so much for joining us to talk about access to justice. Can we start off by talking about the incredible $10 million Beverley McLachlin Access to Justice Fund that was launched on September 10th, 2019?
Yes, may I first say welcome to everybody. Bienvenue. It's a great honor to be with you today, and I hope we have a great conversation. We're relying on many of the questions you sent in, and I hope some of them at least are dealt with and answered. Thanks for your participation. But getting to the Access to Justice Fund, I am so deeply honored that various lawyers and others interested in access to justice decided to establish this fund and put my name on it. I have long felt that we have a need for more sustained funding for access to justice projects. Most of these projects are underfunded. Many of them lurch from crisis to crisis, and this makes it very difficult to develop sustained models of helping people and to do research into how we can improve access to justice. So we're hoping that different groups who care about access to justice will put their proposals forward, and that the independent panel that will vet the applications will be able to provide funding that will really help advance access to justice in Canada.
What can individual lawyers and legal organizations and paralegals, what can they do to support this fund?
Well, the first thing people can do to support it is to recognize that we need more money. Our goal is 10 million, but we're not there yet. And so we want to create a significant capital fund, which of course will never be touched, but enough to provide meaningful funding for the. So the first thing people can do, law firms can do, etc., many have already, and I'm so grateful for their contribution, is contribute more funds. We need more funds to get to our goal. Other things that can be done is to start preparing your resumes, start preparing your applications, start thinking about what you could do to make access to justice a reality in your particular field. And I think those two things will make this a real success.
Can we start at first principles, and can you tell us what access to justice is in your view and why it is important?
Well, I've been a judge I was a judge, I'm no longer a judge. I was a judge in Canada for a very long time, and before that I was a lawyer acting for people who often, even way back then, were not able to get access to hire lawyers, etc. And some of the most satisfying cases I had as a young lawyer were cases for people who had suffered injustices but felt they didn't have quite enough or any money to pursue these injustices through the court. And I was lucky to work with the law firms and people who said, well, let's take it on, let's help them. And when we finally did help them to find justice, to put their problem behind them, move on with their life, it was such a satisfaction. So I guess that's where my idea of the importance of access to justice began. But as a judge, I often saw many, many situations where I really grieved for the fact that people weren't able to afford justice. We always tried our best in crowded courts to do what we could, but sometimes we felt our efforts just weren't what they should be. Also, many litigants feeling they couldn't hire a lawyer and coming in person, which is very difficult for judges, difficult for the court process, yet is necessary if you want to hear their side of the story. So all of that made me think about access to justice. And later, when I became Chief Justice of the Supreme Court of Canada, I thought maybe there's something I can do to raise this issue in public consciousness. So I started giving speeches about it. And I think it's important because everybody's entitled to justice in our society. If we want a different kind of society, we can forget about that. But Canadians want a just society. And I think we're hardwired for justice, and I believe that is a basic responsibility of our governments to provide a good justice system. And that means a justice system that everybody, high and low, moneyed or poor, can use. So I think it's of vital importance, and I think if we don't have a good justice system, when we don't have a system people can use, they'll lose faith in the justice system, and our country will be the poorer for it.
So if we blue sky a little bit here, if you were redesigning the legal system from the ground up, what would it have and what wouldn't it have?
Well, that would take several royal commissions to do, not that I'm volunteering. And but I think if you started from today, you'd look at what is good about the past and what we've accomplished, and there are many good things about our justice system, and you'd ask, how can these optimally work in the modern world of electronic communication, of a very fast-paced life, of people's accessibility to online materials and discussions and functions. And then you would try to keep the best of the past, and you try to merge it with modern technology so that you were truly operating in a 21st century on a 21st century model.
Okay. And are there other countries or jurisdictions that you think we can look to as examples or role models when it comes to access to justice?
Well, I can't really name a single country, and I think some people look to us as a role model, even though we are far from perfect. But one can learn a lot from different jurisdictions. I've learned a lot from the various American jurisdictions, which have developed some very good programs for dealing with family law issues or other particular issues, which have in civil litigation, certain courts have really streamlined the process so that cases don't take as long and they are heard more expeditiously and without sacrificing fairness. I think we can learn a lot by looking at what people are doing in the United States. We can learn a lot by looking at what some people are saying in England. In England, they've had several commissions, and they really seem to be asking themselves how we can harness technology, the internet, and so on, to provide better justice for ordinary people without sacrificing what's best about our legal system.
Do you think that Canada might have an opportunity to be a world leader in that regard? And what might we have to do to make that a reality, if that's something we aspire to?
Well, I think we do have an opportunity, and I'm happy to see that in a number of provinces, real progress is being made in revising court rules, in opening up the courts, in developing more expeditious procedures, in setting up alternative arrangements for people who may want to settle their disputes without going to court and may not need an official adjudication. Other provinces have done less, and we have a lot of different models, and that's the nature of our country. So it makes it, I think what we need now, and the Action Committee is trying to do this, is coordination, getting everybody together to talk about their best ideas. Because as we know, administration of justice is a provincial jurisdiction. So we have these variations from place to place, yet we have many good examples within those places. And so I hope that we can take the ideas we have and learn from each other and build a better justice system.
Hong Kong is much in the news these days, of course. What drew you to join the Hong Kong Final Court of Appeal, and how do you see your role there?
Well, as you may know, since 1997 agreement, part of that agreement was that the British-style justice system would be maintained, the courts would remain independent, impartial, and as part of that, it was agreed that there would always be an external judge. That is, usually in the early days, someone from Britain on the Court of Final Appeal. When I retired from the Supreme Court of Canada, I was asked whether I would be such a judge, and I became the first Canadian to do that, and I was very honored, and I feel it's very important that Canada play its role on these international way. So I'm honored to be a member of that court, and I'll be honored to go out on November 21st and be part of the court, sit as part of the court for 4 weeks. As I say, it's an impartial, independent court, and I'm looking forward to getting to be a judge again for a while.
Do you know already the kinds of cases that you'll be hearing, or?
I haven't been briefed on any particular cases, but it's very much the common law, you know, commercial, private litigation, contract, and anything else that could come up in any of our courts in Canada.
So, the role of governments in access to justice. How do you see the role and the obligations of governments, Canadian governments, in preserving and improving access to justice? Are they taking enough of a leadership role in that regard? What could they be doing more of and better?
Several questions there.
Yes.
First of all, under the Constitution, the provinces have an obligation to set up systems for the good administration of justice. And that is an extremely important role, because justice is at the heart of our constitutional arrangements. So they do have a responsibility, a huge responsibility. The federal government has also taken responsibility because, of course, they are responsible for large chunks of our law, like the criminal code, and they have often worked independently and with the provinces to discharge that constitutional responsibility. Now, are they doing well enough? I think we've seen a lot of improvements in recent years. A lot of some attorney generals who are passionate about access to justice and have taken very concrete steps. Could they do more? Yes, I think there are initiatives I see them from province to province, and I'm not going to name any, but I travel and I say, oh, they're doing this so well in province A. Maybe this province could learn a bit and do a bit better. And of course, there's always the big funding problem. And we may talk later a bit about access to justice, but it is really vital as part of their constitutional responsibility for the administration of justice that provinces provide adequate legal aid, particularly in cases where a person's liberty is at stake, but also in family cases. There is so much more that needs to be done to help our families get through crises, help children find solid footing, help women who have been bruised find a new life. And of course, there are many state facilities that provide this, but if you can't get justice, if you cannot get a solution to the basic legal problems, you're not going to be able to get ahead in those roles. So I'd like to see provinces take these responsibilities really, really seriously.
Yeah. We're in the middle of a federal election campaign. The Canadian Bar Association has been pressing all the parties to find out what they're going to do to have accessible, sustainable legal aid funding. The Canadian Bar has been trying to do that for decades now, you know, and it's lurching crisis to crisis. That's what we see. What more can lawyers do? Is there hope? Lawyers have been banging this drum for so many years.
Yeah. Well, I think there's hope. We can speak out and we can say very clearly that good legal aid is essential to having our courts run well. It's essential to justice, of course, for the individual who is entitled under the Constitution, if the liberty is at stake, to have legal assistance. But it actually makes good economic sense, because if you don't have legal aid, the court process doesn't work properly. Cases take longer. Judges have to explain to in-person litigants as best they can what their rights are. Everything is slowed down. Everything is made more expensive because the court system is designed to work where there's legal representation on both sides. So I believe that you actually save money by providing representation to everybody in our courts. And if we could make that case, then perhaps people wouldn't keep slashing the legal aid budget as the first thing to do when they see that they're facing a deficit.
So is it just a matter of continuing on, speaking out, making the rational case for it?
I think so.
The business case for it?
I think so.
Yeah.
And convincing citizens, because citizens will then tell the politicians, this is important for our country. You're wasting our money, our taxpayers' money, if you don't provide legal aid. It's that simple.
Okay. To what extent do governments have an obligation to undertake substantive law reforms that would promote access to justice? Even though such reforms may not be politically popular, they may not be vote getters, they may be divisive.
Yeah.
You can think of things like overhauling the general part of the criminal code, which experts have been recommending for decades. And I'm also wondering whether we need something like a federal law reform commission to be revived so that they could recommend reforms that would improve access to justice.
Well, I agree with you. I think keeping the law up to date, keeping it clear, is very, very important. We live in such a fast-changing society, and our law needs to be as clear and effective as it can. And I think that requires looking at the law on an ongoing basis and saying, oh, there's a problem surfacing there. We need to fix that up. There's another one here. Let's fix that up. And they're often very minor fixes. And it makes it easier for everybody to do business, everybody to get justice, and simplifies the administration of justice, reducing costs ultimately. So I actually believe that the same arguments I make for legal aid on economic savings probably work for for law reform. You know, as a judge, so often I had to wrestle with parts of the criminal code that were just so opaque, it was hard to explain them to a jury. Self-defense was one. And for years, the Supreme Court of Canada begged the government to, you know, overhaul that. They finally did. And it makes a difference. It makes better trials, because if a judge can't understand how to put self-defense to the jury in the proper way, how's the jury going to get it right, etc. So a little bit of clarification makes everything so much simpler, so much easier. And so we need to have, I think, some dedicated way of looking at where revisions to the law are necessary.
Yeah, and use an access to justice lens. Is that a lens that we could be using when we look at substantive law?
Well, yeah, I mean, access to justice is a very broad thing. If you've got a muddled provision that doesn't make sense, that even judges have to argue about what it means, then justice in the broad sense of getting the result Parliament intended is going to be at risk. And on access to justice, if systems are, in a narrower sense, if systems are opaque, if citizens look up the section of the law that concerns them and they can't understand it, maybe it's something as simple as a tenant's rights. A tenant has a problem with the landlord, tries to read the law, can't understand it, gives up, goes away. There's a failure of access to justice. So yeah, I think it's important to look at it through all lenses, including access to justice, narrow and broad.
Okay. Many women do not want to report that they've been sexually assaulted to police, we've learned. And many do not want to go forward with sexual assault prosecutions because they fear being treated unfairly on the witness stand. Has the legal system struck the right balance in providing justice and fairness to both complainants and accused in sexual assault cases, in your view?
Well, as someone who goes back a long time, I can say that it's much better now than it used to be. I mean, before the 1980 amendments, it was pretty grim. All those old rape myths were out there. Women could be questioned on prior sexual conduct no matter when or where. Massive invasion of privacy, and there were bars to their credibility that made no sense. So in the 80s, Parliament did a whole revamp, and it's a great revamp, and it works pretty well. Could we do more? I'm sure we could. I haven't studied the matter, and I know it's always very hard for any complainant to come and tell publicly these very private stories, and to bear their suffering and their grief and all. It's so easy sometimes just to say, I just want to go home and forget about it if I can, which is usually not possible. So we should do everything we can to ensure that complainants can come forward in the knowledge that the system is understanding them, that the system is there to support them, and that starts with the first complaint, the first encounter with the law in the police station or wherever. And all the way along, the whole system should be geared to provide encouragement and support, because no matter how many rules we have to try to make it easy and fair, the fact is it's going to be really tough, and people will want to opt out or give up at a certain point. So I believe that if we provided that kind of supportive mechanism, it would really help. The other thing I think is important that women, and this is happening, women are now talking about what happens to them and how it hurts them, and that's with the hashtag #MeToo movement and so on. And I think that's really important, because for so many centuries this whole area was cloaked in silence, and there was this unwritten social rule that women couldn't talk about violence done to them, whether it was in the home or outside the home. And now women are starting to, the young women today are saying, enough. We can talk about the wrongs that are done to us in this area of sexual conduct, just as we can talk about the wrongs done economically, or by a car that strikes me on the road, or somebody who says something bad about me through the law of defamation. I think that's a really important development. So I'm hopeful that with those efforts we will be able to make the needed improvements in this area of the law.
Do you see the Charter as being a possible vehicle for change and enhancing access to justice?
Well, yes, and it already has been. We've had law cases where, for example, fees charged by governments, provincial governments, to get your case heard in court have been struck down because they were prohibiting people from getting justice. Justice is a basic right, and the courts have said so under the Charter. So I think the Charter can be used to provide access to justice. And beyond that, it can be used, and we've seen this too, to help people gain more control over their lives, to get rid of injustices in the law that are holding them back or keeping them down.
Okay. Climate change. It's arguably the most pressing human and animal rights issue of our time. But it also presents an obvious access to justice challenge for the youth and for the unborn generations.
Yeah.
Can the legal system and our Constitution potentially provide avenues to tackle that issue? And we have lost litigation here in Canada already, in Quebec.
Sure we do. And you know, I think the main obligation constitutionally for tackling this major problem rests with the federal government and the provinces. But courts are part of the picture because the right to life, liberty, and security of person is something that all of us are entitled to, and climate change may tie into that. In addition, the courts have long been used to monitor environmental processes and vet developments that may have a negative impact on the environment. And now we're seeing people starting to bring lawsuits on a broader basis to protect the environment. It'll be very interesting to see how the courts deal with them.
Is the legal profession, in your view, doing enough to combat bias and racism and to eradicate systemic barriers that impede equal opportunity for racialized jurists within the bar and the bench?
Yeah. Well, enough is a big word, and there are those who would definitely say not. I think that I think they're doing a much better job than when I began practicing law. There is now a conscious recognition within law firms, within the legal profession, that the profession has an obligation to maintain non-discriminatory standards in hiring, in access, that the justice system is there for everybody, of every color, of every way of dressing, of every ethnic background, and that it has to be seen as, if you wish, a beacon for an accepting, non-discriminatory atmosphere. And so I'm hoping that law firms more and more are seeing themselves as the example, the shining example, shall we say, of diversity. Are we there yet? Obviously, we are not, but I'm very hopeful that we're on the way.
Okay. So the chair of the Truth and Reconciliation Commission, Murray Sinclair, has said that Canada has to move from apology to action. How is the legal system doing in implementing the Truth and Reconciliation Commission recommendations?
Well, I haven't, that would take a study, and I can't answer that precisely because I haven't looked at it. I think attitudinally people are there and the legal system is there. What we do need to do, as Senator Sinclair says, is find ways that we can take concrete action to address the recommendations and to avoid this terrible situation of the missing women and the marginalization of many Indigenous women.
Is cultural competency an important part within the legal profession on the bench? Is that an important part of access to justice?
But cultural competency, you mean an understanding of different cultures and so on?
Yes, and
absolutely.
cultural competency in Indigenous, yes.
I think we're going to, we see already a huge change in that Indigenous law is talked about and taught at our law schools. It's talked about and features in our court processes. Is it where it should be? No. But we have really changed from a legal system that culturally saw the law through the Eurocentric lens to the acknowledgement that that's not good enough. And we have to look at our law also through the lens of cultural minorities and in particular Indigenous people. And it's such a fruitful area of scholarship and endeavor. And there's so many wonderful young Indigenous teachers and lawyers and scholars now coming forward. So it's a very exciting development in our law.
And we have a number of very distinguished Indigenous jurists. Do you think that the time has come to appoint an Indigenous jurist to the Supreme Court of Canada?
Well, I certainly hope that will happen soon. I mean, we need to have a Supreme Court, and I've said this many times, that reflects the diversity of Canadian society. It's not always possible, and this is the government's problem, to do that for various reasons, because of the fact that judges on the Supreme Court have to have been in the system for a long time and so on. And some of the rapid changes that have been happening in the last couple of decades haven't yet shown up at the Supreme Court level. But I'm confident that this will happen soon, and I look forward to that day.
Mandatory minimum penalties, they disproportionately impact Indigenous people, which is part of the reason our jails are overflowing with Indigenous people. Do you think that repealing MMPs or otherwise ameliorating them, like with judicial safety valve, adding in discretion, would that enhance access to justice for Indigenous people?
Well, I think it's probably evident from my rulings when I was on the bench that I think it's usually a mistake to eliminate judicial discretion in sentencing. And it impacts particularly hard on juveniles and on Indigenous youth, because when you set up a mandatory minimum, especially for we're not talking the highest offenses here, what you're basically doing is preventing the judge from looking at the background of that person, from looking at why they got where they were, from looking at how serious a threat they are to society. You say to the judge, you've got to approach the sentence with total blinkers on. You have no say. And so all of the other things the criminal code says to do, like take into account the Gladue provision, take into account the Indigenous background, the judge can't do it. Well, there's a blatant contradiction there in our criminal code. That can't be good. And I think that judges take sentencing very seriously and will try to do their best job if you let them look at it. If we don't do that, then we risk, and we do, send young people, young Indigenous youth, into prison for sometimes lengthy periods for relatively minor things. And prisons are a school for crime. You talk to any young person who's been there and they'll tell you that. And then we condemn them in many cases to a lifetime of revolving prison door. We call it revolving door syndrome. And that can't be good for society, costs a lot of money, it wastes tremendous potential. So I'm very concerned about this situation.
Do you think ideology should be kept out of the criminal code?
Well, I mean, it depends what you mean by ideology, but there's a lot of morality in the criminal code, and you can't divorce crime from morality. But I think it should be it should be as neutral a document as possible, and it certainly shouldn't be jigged every time you have a change of government to represent this view or that view. I mean, ultimately the goals of the criminal justice system should be pretty consistent, and they are rehabilitation. There's also deterrence. There's also, we're told by the criminal code, a degree of retribution, but I think most judges would say it's really, really important to have the criminal code and work in a way that results in convictions for wrongdoing, but doesn't unnecessarily condemn young people to a life sentence in the jails.
In the name of promoting speedier and more affordable access to justice, we've seen the emergence of do-it-yourself tribunals, online tribunals like the British Columbia Civil Resolution Tribunal. What do you think of this method of resolving legal problems?
Well, I haven't studied it, and I haven't studied the British Columbia Tribunal, so I can't offer an expert opinion, but I do believe from what I read and understand that there is a role for using, devices like online programs and other programs, informational programs, and well-run and well-designed tribunals to help people get justice. If you're, I use the example of my son many years ago when he was living in an old house in Vancouver, and the landlady wanted to get rid of him, and she wanted to get rid of everybody in the house, I should add, not just my son, and because she wanted to do something else with the house, and everyone else moved out when she presented the vacancy notice, but he didn't, and he went to City Hall and found out that she couldn't really. So they had this little dispute. At that time, they were able to, by telephone, go into a process where an adjudicator set up the rules. Nobody interrupts. I listen to this person, I listen to that person. You'll have a chance to ask questions. To make a long story short, the first telephone trial, if we can call it that, the adjudicator said to the lady, well, you haven't got the right to get rid of your tenants. And she said, what do I have to do? He said, well, you either have to sell the house or you have to get a demolition permit. So she went, and next time she tacked on his board the application for a demolition permit. But that wasn't good enough either. They had a short second session. And then ultimately she did what was necessary, and my son and she parted friends. She said, I have a pickup truck, I'll come and help you move out, and they went to Starbucks for coffee. Well, that's a very simple example, but it's an example of access to justice through a simplified tribunal. Nobody had to lose any work. Nobody had to spend any money, really. They just had to tell the problem, and they got a solution, and they ended up friends. That's what the justice system does at its best. So I'm all for things like that, provided they work.
And so in the name of efficiency and expedition, we are seeing the growing use of mandatory arbitration clauses in some non-traditional areas, including in the labor context, where critics are saying they're being inserted into employment and service contracts by companies, not with the aim of effectively resolving their workers' claims, but to limit the enforcement of individual worker rights. Under labor legislation, is there a danger that arbitration can be used as a barrier to access to justice?
Yeah. It can be misused, if I can put it that way, and powerful corporations, big media corporations that are supplying services or computers can write in these mandatory arbitration clauses, and that means that if we had a case like this in the Supreme Court of Canada, an ordinary person has a contract with a Dell company or somebody like that, you know, at Bell Telephone. I don't want to use names here because I may not use them inaccurately, but you have a consumer contract, and in that contract, there's a clause that if a certain thing happens, your service is not provided properly, you have to go to mandatory arbitration. You read the fine print, it's over in Europe somewhere. And no individual is going to do that, even if they had the money, because for the small amount involved in their particular contract dispute, it doesn't make sense. So mandatory arbitration clauses have been used in that way, and the courts are finding ways to get around that.
Okay. What about the use of artificial intelligence to increase the efficiency and lower costs? Is AI something that the legal profession should be viewing with cautious excitement or cautious trepidation?
I don't know. I still, perhaps I'm prejudiced because I was one, I still like the idea of a human judge. And I read about an experiment in a United States jurisdiction where on bail and sentencing they developed an AI program that would take a lot of factors into account and decide whether the person could get bail, and if it was a question of sentence, what sentence it should be. And that sounds very good. They were cautious enough to make sure the case would actually be decided by a judge, but it was quite interesting. And apparently in 90% of the cases, the judge's decision actually was in line with the AI decision. But the concern that was raised is that those factors can become markers for racial background or other biases, and you have to be very wary of how you set up those programs so that you're not suddenly saying, because this juvenile defendant comes from this area that happens to be totally black, his chance of reoffending is greater, therefore he shouldn't get jail. So that would be wrong. And the great thing about having a real judge is that the judge can take account of that and can weigh those factors and make sure that they are not driving the decision, that it is the individual considerations that are driving the decision. So AI, interesting idea. I think it's kind of interesting that some people are playing around with it, but so far I'm not convinced that it will replace human judges.
Yes, and that concern is being raised by the immigration bar with respect to the increasing use by the federal government of artificial intelligence. The bar wants to know more about that and ensure that biases are not working in. So that would be a fair concern in your view?
Absolutely, yes.
Yeah. So what progress do you see in assisting people to self-represent themselves in court and to resolve their own legal disputes?
Yeah, well, given that our reality today is that we have a lot of self-represented litigants, sometimes in the criminal system due to lack of legal aid, but markedly in the family law system and in less major civil disputes, but particularly family. So what is being done? Well, a lot has been done in terms of giving people involved in these issues information, in providing courthouse advisors, in allowing unbundling so they can get legal advice and maybe even a lawyer to go into court for part of the procedure. So there are many ways of proceeding, many options that can help alleviate the burden and make the in-person litigant more effective and allow them to get justice. It still remains a difficulty, though, that courts worry about.
So Are the law societies actually primarily responsible for ensuring that there is justice available to everyone?
Well, I don't know. The way I see it is that that's a constitutional responsibility of the provinces and to some extent where they're involved, the federal government. That is the basic responsibility. But law societies are responsible to ensure that their members provide justice in the courts as best they can in a non-discriminatory and egalitarian and effective fashion, because first of all, that's what lawyers are supposed to be doing, but second, lawyers have a monopoly. If they don't do it, usually nobody else can. So the quid pro quo is they have to do it well.
So is there an inherent conflict of interest, though, that law societies are run by lawyers, and so we have paralegals, alternate service providers coming in and maybe trenching a bit on the lawyer's territory, and yet it's the law society who's deciding the scope of practice of paralegals, for example. Are the interests aligned of the law societies, the legal consumer?
Yeah. Well, I hope that lawyers, including benchers on the law society, when they take up their job as representing the law society, they assume an obligation to look at what lawyers should be doing for society and ensuring access to justice. They have to put on a different hat. I wouldn't put it in terms of a conflict of interest. When you take on a public responsibility like that, you take on with it the baggage, and part of that is making sure that the legal system, that lawyers serve the legal system well. Mm-hmm. And I don't call that a conflict of interest. I think that's in the interests of lawyers.
Okay. And apropos of that, should the regulatory environment of the practice of law be changed to create a more permissive and business-centric model that would support a wider array of options for such legal needs? An example would be to permit non-lawyer-owned law firms, so that you can take advantage of outside money and expertise.
I'm not here to tell people how the basic legal system should be organized. I think the traditional system has served us very, very well, and the high ethics that are maintained by law societies serve the public well. I've read about all sorts of things like, storefront legal services and so on. I have a personal point of view, which not everybody may share, but I think the best chance for justice is when lawyers are involved, at least at critical points. Paralegals are wonderful. They've always been with us. When I started off practicing law, they called them secretaries then, but they did most of the real estate transactions subject to checking by a lawyer. But the important thing to me has always been to have that checked by the lawyer. And to have the lawyer who understands the broad responsibilities of the lawyer toward the justice system, making those decisions in where they are necessary.
Well, futurists are predicting that lawyers are going to disappear, that maybe half the bar is going to disappear, that solo practitioners and small non-specialized law firms are going to disappear. And because of the business environment that exists currently, I'm wondering, do you have any concerns about the size of the bar going down? I mean, the bar is it upholds the independent bench, and the independent bench upholds democracy. So if we lose lawyers and everybody's doing it themselves, and is that a problem?
Well, there's a big assumption in that question, and that is that people are going to stop going to law school, people are going to stop practicing law, and lawyers will not disappear, but there won't be very many of them. I mean, futurists may have evidence I'm not aware of, but I have a hard time accepting that an increasingly complex society is going to need fewer lawyers. Because wherever you have a complex situation, you have complex disputes, you have complex interweaving of interests, and you know who's best at working those out? Lawyers. Because lawyers are trained to take messy situations, be they small ones, large ones, in-between ones, and sort out rights and wrongs and sort out arguments and put some sort of form on these difficult situations. That is what lawyers do better than anyone else. Will they do it in the same little corner office? I don't know. But I think those skills that lawyers bring, including upholding the justice system, are going to remain vital to our society.
So what can lawyers do to provide more affordable legal services?
Well, what I see hundreds of them doing, quite frankly, I've been very impressed at the amount of pro bono that individual lawyers and law firms are providing, at how they have built pro bono into their practices and how this has increased over the last decade or so. I find that very, very impressive. I think lawyers are contributing to many NGOs and other organizations that are concerned with access to justice. I see it every day. Lawyers are not all Bay Street lawyers. A lot of them are working in the trenches with the poor, with the juveniles who find themselves involved in justice issues, with Indigenous people. Everywhere I go, I see lawyers working to make the justice system better.
Well, on that note, what's your view on mandatory pro bono for lawyers? Are lawyers doing enough, and how could they do better?
Well, I think they're doing better. And, you know, the word mandatory, who's going to make it mandatory? Is it a good thing? But what we need to do is change the culture. And we are changing the culture, I believe, so that every lawyer says, I have this great privilege of practicing law. I can make a living with it. I'm the only person, I and my fellow lawyers are the only people who can do this. With that comes a responsibility to make sure that people get legal representation when they need it. And I think that is more and more accepted by the legal profession. And that's what we can do, is make that acceptance a general rule. And then we won't have to worry about the word mandatory or how we're going to police it and all of those other difficult issues.
Okay. And so we got a lot of questions from people saying, how can I help in my particular circumstances? So, for example, what can a lawyer with a busy practice who is raising children do to promote access to justice?
She can go to her children's school and talk about the importance of the justice system and the importance of access to justice. She can work within her profession and with her colleagues to talk about access to justice. And if she has a little time, she can go to a pro bono clinic, or she can go to a meeting where fellow lawyers talk about it. She can contribute to an NGO. She can give some money, if she has sufficient, to some group that is working with Indigenous people or the needy people in our jails, to keep kids out of jail and keep them on the right track. There are many, many such groups, and best of all, she can just say, I'm there for access to justice, and I'm going to practice it as much as I can in my day-to-day work and do whatever I can to promote it outside my day-to-day work.
And what would you say, what would you advise new lawyers who are committed to providing more access to justice, but they're burdened down with very high loans and they are working all hours to try to pay off their student debt?
Well, you know, you do what you can, and I completely understand that not everybody's in a position to give money, to support an NGO, or to work, or to give their evenings, and actually do on-the-ground work. There may be times in your life when it's very difficult. There may be times when it's easier. But I think you should always do what you can to support better justice for everybody.
So we had questions too from single practitioners, solo practitioners, from medium-sized law firms, large law firms, asking what can they do, and also from in-house counsel. What would you Do you have a few words for each one of those?
Well, you know, one thing that really has impressed me since I've retired and taken the chair of the Action Committee is how many groups there are and how diverse they are, and how many different ways there are to contribute to access to justice. Maybe you just go to a school and talk for a while about how you would access the justice system if you had a problem. There are many, many ways to do this, and I think each person has to find their own ways. But just look around in your community and you will see a lot of organizations that are dedicated to promoting access to justice, and decide to take on one or two and provide what support you can.
And what would you advise a young person who's thinking about becoming a lawyer in light of the current concerns about the future of the legal profession and the affordability of legal services? What would you say? Is it a good profession to go into?
Absolutely. I think it's a profession where you have such a privileged role to help people find justice. What can be more important? And it is a real role. Lawyers do that. And when you go to law school, when you take this on, you have taken on a very special calling, but you have assumed the very great privilege at the same time of helping sustain individuals who are involved with the justice system, but also sustain the justice system itself, and through that, our democracy.
And I want to talk a little bit about paralegals. Do you think that new types of non-expert legal service providers like paralegals, although they're highly trained, are improving access to justice?
I haven't done any studies, but I certainly think, I see no reason to think that they aren't. I think we need to be flexible and provide legal services of the highest quality in the most efficient way possible. So if it involves delegating certain tasks to a paralegal, and we still achieve those goals, I'm all for it. Perhaps it can lower costs and improve efficiency. Similarly, using internet, electronic mediums can help us achieve better justice. More efficient and more just. Those are the two criteria. At the end of the day, you want fairness and you want efficiency as much as you can. And if we can use whatever we can harness to make that the case, then I think we should do it.
Okay, so given that, would you do you think that paralegals should be under the supervision of lawyers and accountable?
I'm not going to go into that. That's governance issues that I'm not qualified to. Talk about.
That's fine. What do you think would make the biggest difference going forward to enhance access to justice?
Well, I think it's an attitudinal thing. I think that if Canadians can be convinced, A, that they're entitled to justice, and secondly, that justice is extremely important for our well-being in Canada and the survival, indeed, of our democracy, then I think we would build support for access to justice that would transmit itself into new realities and improvements on a host of fronts. And so I think it's important for people to realize how important access to justice is. And when they do, I think a large part of our problems will be solved.
Thank you. And on that encouraging note, thank you very much, Ms. McLachlin, for sharing your vast expertise, your deep insights, and your words of wisdom. And thank you all for participating in the LexisNexis webinar, A Conversation with Beverley McLachlin on Access to Justice. Merci d'avoir assisté à cette présentation et bonne journée.